Welcome to this edition of Real World Employment Law, where we discuss real-world issues impacting businesses and executives. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard. I also head up the firm's employment law practice.
Good to be here, Declan. I'm Nick Johnson. I'm a partner here at Berenzweig Leonard, and I also work with you in our firm's employment practice.
So, Nick, we've been dying to get into the studio to talk about the Biden administration's new executive order dealing with non-compete agreements. You and I litigate these all the time. It's a big part of our practice. What's this all about?
Yeah, so earlier this month, President Biden, he issued an executive order, and it was an executive order on promoting competition in the American economy. And it's actually a fairly sweeping executive order. There's over 70 initiatives targeted at various different industries, different areas of concern, all kind of focused on competition. But one of the initiatives that has gotten a lot of attention, particularly in our area, is a focus on potentially limiting or outright banning the use of non-compete agreements.
And this has gotten a lot of attention. What's interesting is, like you just mentioned, I think there was over 70 initiatives. There's a very long document. One little paragraph dealing with non-competes, and in fact, I'm just going to read it real quick, just so that everyone out there understands like what we're dealing with. Here's what it says, and here's what's generated so much attention. It says, to address agreements that may unduly limit workers' ability to change jobs, the chair of the FTC, that's the Federal Trade Commission, is encouraged, okay, so he uses the word encourage, to consider working with the rest of the commission to exercise the FTC's statutory rulemaking authority under the Federal Trade Commission Act. And so here's the important part, to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So that's, I mean, it's one sentence, not even a paragraph, one sentence. And so that's so is this just going to eradicate non-compete law, non-compete litigation, and you and I are going to have more time to play golf? Like, what's going to happen here?
I mean, as we sit here today, the answer is no. And I mean, I think there's a number of things to unpack in what you just read in, which is, most importantly, one, this is not law. This is, I mean, let's call it what it is. This is really aspirational in nature. And so, businesses, executives, they don't need to go out there and completely rewrite their employment agreements because of this executive order. It's really, it does two things. The executive order, it creates a White House Competition Council, but then it also, as you noted, it directs various federal regulators to look into these areas to potentially go through the rulemaking process and pass rules.
And if nothing else, what it does also signal is that this Biden administration doesn't like these agreements at all. So when we talk about non-compete agreements, that's, in my opinion, you and I have been doing this for many, many years. I sort of always wince when I hear the word non-compete because we know they come in so many shapes and sizes, right?
Yeah, that's right. And so non-competes, they fall under the restrictive covenant umbrella, and there's many different types of restrictive covenants. And so let's even just take a step back even further. I mean, what is a non-compete? What is a restrictive covenant in the employment context? And so, oftentimes employees in their employment agreements will find contractual provisions that limit what they can and can't do both during employment and post-employment. And those are commonly referred to as restrictive covenants. Now, there's many different types of restrictive covenants. There's your typical non-compete, which basically says when you leave or during employment, you can't go work for a competitor. So if you're working for Coca-Cola, you can't go work for Pepsi doing the same or substantially similar thing. There's other restrictive covenants targeted at protecting employees. And so those are commonly referred to as non-solicitation or non-hiring provisions. And so during employment or for a period thereafter, you can't recruit or hire your former company's employees. Another category of restrictive covenants, you have non-solicitations or non-servicing of customers, designed to protect the company's clients / customers. And those, again, are, for a certain period of time, you can't do work for, solicit, engage with the company's business or the company's clients. And then I would say just more generally, confidentiality agreements and non-disclosure agreements, they fall under the restrictive covenant umbrella.
So this has sparked a lot of discussion as to what exactly the Biden administration really wants to get at here. Are we talking about non-competes? Are we talking about other ones? They had that phrase in there when I read that. It says to curtail the unfair use of non-compete clauses. And then there's this thing, and and other clauses or agreement that may unfairly limit worker mobility. So it's really kind of unclear right now whether they're really just going to they're going after the larger non-competes, which you and I know are sort of they're not used as commonly anymore, are they?
No, they're not. And I mean, I think, this executive order has raised a number of questions. I mean, you correctly pointed out, that phrase, other clauses. I think, the press release that accompanied this executive order, it referred to, a ban on non-competes. Well, that's a lot different than the word curtail.
Yeah.
And so when you and I look at the word curtail, you think maybe the federal government's going to do something like you see on the statewide level, where they're limiting the use of non-competes with certain employees, certain low-wage earners, things like that. It's not really clear.
Yeah, I mean, I think you've hit it on the head that they're really getting at, and again, we're speculating at this point, but they really want to focus on not the highest level of employees, because you can always justify those, but probably more run-of-the-mill or lower-level employees who don't really necessarily always possess the trade secrets or the secret sauce, such that when they leave, they really don't have a leg up to compete against the company. And in fact, it doesn't say. Let's see. It doesn't say curtail the use of non-compete clauses. It says curtail the unfair use. So they're not looking to ban non-competes, from the way I read it, at least. What do you think?
And that's how I read it too. And I mean, I think you've seen on the state level, states take a similar approach. I mean, I think we spoke on this at one of our real-world employment law sessions about what Virginia did just last year.
Yes.
When they passed legislation banning non-competes for certain low-wage employees. You saw a couple of years ago, Maryland passed very similar legislation where in Maryland, you cannot impose non-competes on low-wage employees. California is one of those states.
California's always been, yeah.
It just has an outright ban on non-competes,
yes,
regardless of your income or what you make. D.C. has passed similar legislation. That one's kind of in a different situation.
It's in a holding pattern a little bit, yeah.
Exactly. But they did pass a ban on non-competes. There's an amendment, and there's questions as to what will ultimately be implemented into law in 2024. But you are seeing a number of states pass laws that are aimed at limiting the use of non-competes for certain employees.
Okay, well, let's take this worst-case scenario. Let's just say what the Biden administration is really aiming at here is just really eradicating any of these, let's call them restrictive covenants. Does that mean employees just kind of have free rein as they jump from job to job?
I don't think so. And I mean, I think there's a big if. I mean, because, in order for this to become law, it most likely needs to go through the rulemaking process. There's opportunities for comment, and there's probably going to be legal challenges. But let's just assume that this law is passed, or some form of this ban on non-competes is passed. Companies are not left without recourse. There's trade secret protection. There's confidentiality protection. Employees, at least in Virginia, they owe their companies what's called a duty of loyalty while they're employed. So there will be protections that remain available for companies to protect things that they, obviously care about in terms of sensitive, confidential information.
Got it. So there have been some high-profile restrictive covenant, non-compete, whatever you want to call them, disputes that have made the press. The car share companies like Uber and Lyft. One employee, high level, taking very sensitive trade secret information, going to the next one. That's probably not going to. That's not going to be permissible no matter what. I would guess no matter what the FTC does here, right?
Yeah, that's right. I mean, when we're advising companies on this, I like to say, less is more. You don't want to impose these restrictive covenants on every single employee. I mean, if you have, college-age interns that you're imposing non-competes on, I mean, that's probably going to be susceptible to legal challenge.
Yeah.
But rather, you need to take a look at your workforce. You need to take a look at, okay, who is actually serving as the face of my organization? Who am I entrusting with sensitive, confidential information? That it makes sense to perhaps have some of these restrictive covenants. You can't take we're going to impose these non-competes across our entire organization, regardless of level. I mean, that's where you're going to find yourself subject to legal challenge.
Yeah, I mean, Jimmy John's, has gotten a lot of flack, and I don't actually know where that stands right now in terms of that dispute. But they were imposing restrictive covenants on, their sandwich makers. It's just like, that is not a trade secret. That is not confidentiality at all. I mean, it just isn't. And so, I would think that would be an example of something that could be caught up in this Biden administrative executive order. That would be something that I would think, and some of the states, as you noted earlier, have already started to outlaw those on just, they kind of like defy common sense, the fact that you need to impose a restriction on a sandwich maker at Jimmy John's so that they can't go over to Jersey Mike's or whatever.
Right. And, another thing that I think, businesses can do, in the meantime, while we're kind of waiting to sort this out is, we talked about looking at your workforce, but I think also take a look at your employment agreements and see, look at the governing law section, see what state law applies to your employment agreements. As we talked about, I mean, depending on what state you're in, if you're in California, the use of non-competes is outright banned. So if you have an employment agreement governed by California law, you need to be very careful there. Whereas, if you're in Virginia or Maryland, it may come out a little differently. So take a look at your governing law provision, see what state law applies.
Yeah, and it's not just the choice of law. It's not just what state's law is going to apply if there's a dispute. It's also the forum selection clause, which a lot of companies sort of miss that. They don't put that second part into the agreement, which is, look, here's what law applies, but then forum selection. Here's where we're physically going to resolve any disputes. I mean, we want those to be perhaps here in Virginia with remote workforces, even, more so than ever because of the pandemic. You want to make sure that you're not going to find yourself in many, many different states who, even if they think they're going to be applying Virginia law, might not always do so.
Right. Good point. Very good point.
Yeah. Nick, great discussion today. It's probably a to be continued. Nobody knows. Government doesn't always move at lightning speed here. So there's probably a lot that's going to come down, but it does show that this is very much in the minds of this administration. That means it probably will be pushed down to the states pretty soon.
Agreed.
Great discussion. Thanks, everyone, for joining us here for Real World Employment Law.
Thanks.